Talk, KLSU's official news podcast. I'm Kierra Evans.
I'm Kathryn Slaton.
And I'm Makala Borland.
And today we have the pleasure of having Barry Erwin, the Chief Policy Officer of Leaders for a Better Louisiana, on our podcast. Mr. Erwin, how are you today?
I'm great. How are y'all?
We are wonderful. How are you guys?
I'm doing great.
Doing good.
Wonderful. Now, jumping straight into it, can you tell us a little bit about your organization?
Yes. Well, actually, we're sort of a new organization made out of two older organizations. I was involved with the Council for a Better Louisiana, or CABLE, as some people may recognize that name, for a very long time. CABLE had been around for 62 years or so, and we were nonpartisan, nonprofit organization that kind of works on public policy at the state level, trying to raise awareness about issues that are, we feel are important to the state. A lot of it had to do with education, state fiscal policies, governmental ethics, all of those types of things. And then we merged with another group called Committee of 100 for Economic Development, which was a group of a lot of executives from around the state with companies who also, I think, shared the same vision we did about, improving the state. And so just in January, our organizations merged. So we're kind of a new kid on the block with a bunch of old people around too.
That is wonderful to hear. And just to follow up, how new are you guys? When were you guys founded, I should say?
Well, originally our organization, CABLE, was founded in 1962. So we've been around for a long time. The other group was founded in 1992. So we were about 60 plus years old. They're about 30 plus years old. So we've kind of been around the block in one form or another for a while.
Wow, a long time to make some change.
Yeah, for sure. So we're going to dive into some of the questions that we had prepared about the upcoming election. So for those who don't know, we have an upcoming election on March 29th. And can you quickly go through what's on the ballot, and we'll press for more details later?
Well, it's short. On the one hand, there are 4 constitutional amendments dealing with 4 different things, but one of them is a major, major change. We've never really done this since the Constitution was approved by voters in 1974. But in this case, we have undertaken a rewrite of one of the entire articles of the Constitution. Now, I can't remember how many articles in there. There are 10 or more of them. But this is Article 7, which is a big piece of the Constitution that deals with state and local finances and fiscal issues, taxes, and all of those things. So unlike in the past where voters would get these constitutional amendments and they're, they can be complicated, but they're basically short things. You want to change this or change that. This is an entire rewrite of a big section of our Constitution. So voters will have 3 kind of normal amendments on there and 1 big amendment on there. And we can go through them any way you want to.
Yeah, go on right ahead.
Well, you want to start with number 1?
Yes.
Yes.
Number 1 is one of 2 on the ballot that deal with the judicial branch of government. And this one, it's kind of technical and kind of not something most people probably think about. But, it deals with the court system, and it actually does 2 things. 2 things that are not even related. The first one is pretty simple. The Supreme Court has the jurisdiction right now to discipline attorneys in the state for unethical behavior. If they're, part of the Louisiana bar and they've, been approved to practice law in Louisiana, they have the right to discipline them. That's been the case for a long time. But the Supreme Court doesn't really have any authority to discipline attorneys from out of state. And so the first part of this amendment would just say, okay, now we're going to give the Supreme Court some authority to discipline out-of-state attorneys. And why are we doing that? A lot of it has to do from hurricanes in recent years where attorneys from other states have come in and, allegedly engaged in unscrupulous and maybe illegal practices. But anyway, it gives the Supreme Court the authority to do that. That's kind of straightforward. The other part of it, though, is the legislature has the authority to create what they call specialized courts of jurisdiction for specialized type things. So what we're talking about here is we have the regular courts people know about, the district court, the appellate court, the Supreme Court. But, some places have juvenile courts, places have drug courts, some have family courts. And the legislature can create those kind of specialized courts within a parish. What this amendment would do would be allow them to create those same kind of specialized courts, not just within an individual parish, but across the entire state, like a statewide, whatever court, or, a regional one where maybe you had 4 or 5 parishes, 2 or 3 parishes, whatever, would all have the same, let's say, juvenile court covering that area. So that amendment is 2 parts. It does 2 things, but it's one amendment dealing with the court system.
All right. And, well, I think we do have a question about this First Amendment.
Yeah, so
Okay.
When people are looking at this amendment, can we dive a little deeper into it? Can you give us a couple of words or phrases that might help voters really determine like how they should vote for this amendment? Because if you're just looking at it from a casual perspective, if out-of-state lawyers can already be disciplined or disbarred, then what exactly is the purpose of this amendment?
Well, the out-of-state lawyers can't be disciplined by the Supreme Court. It's because the way it works in Louisiana, if you're out of state, mostly lawyers within the state have to pass the bar examination in Louisiana. So you have to be within the bar in Louisiana. But what happens is out-of-state attorneys can come to the Louisiana law firm and actually do a bunch of legal work under the kind of umbrella of that Louisiana law firm. So the court has the authority to discipline the Louisiana law firm if something unethical happens. But a lot of times, especially like in some of these hurricane cases, it was really some attorneys from Texas that were coming in, partnering with one little local law firm. But the Texas lawyers were really doing all the work. And so there was nothing that the Supreme Court could do anyway to discipline those folks if they felt like their behavior was unethical. Now, if they break the law, and there were some allegations of that, you could have criminal investigations. The FBI was looking at some of them, some local law enforcement and all that, but the court couldn't do anything. So they would still probably be limited in what the court could do, Supreme Court, but it would give them a little bit more authority, to sanction them or do something theoretically than they have now.
All right, thank you. Moving straight along to Amendment 2, I know taxes have been a big sticking point for land use administration. So what taxes would Amendment 2 change, and who would that go into effect?
Well, this is the big one. This is the one that's the really big deal. So we might have to spend a few minutes on this one, but it really does a lot of things. I mean, you've probably heard, some of the discussion in the past about having a constitutional convention and rewriting the entire Constitution. We never got that far, but we did have this effort during the special session back in November to rewrite this one big article dealing with taxes and local government in there. So it really does a number of things. So mostly Article 7, it's our longest article in the Constitution, and it's also the one that's been amended and changed the most. So a lot of times when you have these constitutional amendments on the ballot, you're amending this article. So what the big goal was, I think, was to do a couple of things. One, to streamline it, to shorten it, to kind of take stuff that we have been putting in there over the years out of it to make it more, again, streamlined than it is right now. And the other thing is, because it's the Constitution, it puts a lot in some areas, restrictions and protections or preservations, depends on the word you want to use, on certain dollars that have come in from, legal settlements and from other things that are dedicated within the Constitution, which basically means they go to certain things and the legislature on its own can't come back in and take those funds or redirect them or do anything like that because they are protected in the Constitution. One of the arguments has been, well, when we get in these budget cuts and we're having to cut, higher ed or health care, it'd be nice to have the legislature have the flexibility to kind of go in and maybe use some of those funds in a limited fashion, whatever. So this amendment, another thing that it's going to do is give the legislature some authority to do that a little bit more than it can right now. In fact, a lot more. Some of these funds that have been protected for a long time are going to lose some element, not all of it, but some element of their protection in the sense that the legislature could change them or actually take funds out of them, or even take the corpus or the actual base amount out of the money with a 2/3 vote of the legislature. So that's kind of a really big change. One of the other things that it does, we have a lot of debt in our teacher retirement system. So not so much for the folks in higher ed, although there definitely are some, but especially in K-12 education, there are a lot of teachers, just about all of them, who are in the state retirement system. But because of reasons we probably don't want to get into, over decades, we have gotten into debt in that retirement system so that we owe more money than we actually have enough to pay out. So we've been trying to pay that back, pay it back to kind of come up to speed and pay off that debt. And we've been doing a pretty good job. But what this would do is take some funds that are already in the Constitution, where we've got a lot of money, and frankly, some of them come from dedications to education and particularly to higher ed. But the notion was to eliminate those funds, get rid of them, and then instead use those dollars to pay off a big part of that debt in the teacher retirement system. And that would lead to a pay increase. I mean, you can argue if it's a pay increase. Teachers in K through 12 have been getting a $2,000 stipend for the last 2 years, but it's not been permanent. It's just been a 2-year, you have to do it year over year after year. This would have made that permanent, that $2,000 pay raise. And in doing so, also free up some money for higher ed in particular to use the dollars that it was using out of this trust fund, which I know this is complicated that we're discussing, but to take money that would be coming out of this trust fund that would be going away and use it for other purposes in higher education. Now, it does a few more things than that, but those are kind of some of the high-level pieces that it does. And we can talk a little bit more about some of the other aspects if you like.
Okay. And I know this is a very big amendment. So is there anything like a word or a phrase that voters can think of to help them remember what the ballot is about? I'm sorry, the amendment is about?
Yeah, I think, I think the thing that was the intent behind it, although it really does a lot, is to streamline, give the legislature more flexibility on fiscal issues, and take some tax exemptions that we have that are like super protected right now because they're in the Constitution. Take those tax exemptions, and they mostly deal with property taxes. Take those property tax exemptions out of the Constitution and then give the legislature, kind of the authority to review those in the future if they wanted to. So it's kind of streamlining, making it not as long, giving lawmakers more flexibility in some areas dealing with money primarily, kind of moving around some tax exemptions, freeing up some funds to give teachers a pay raise, all of that and more. So it mostly deals with, some taxes and some fiscal policies at the state and local level. But that's this one. I just have to tell you, this amendment is 115 pages long, the law that it's changing. So nobody's going to read that. I will tell you, when the week is over, by the end of this week, we hope to have something on our website that will give you a much more condensed version of what this does, and hopefully understandable too.
Yes, that'd be very helpful.
Yeah, so we're going to move on to amendment number 3. Would you mind giving us a little bit of a rundown on that one?
Yeah, this one deals with kind of juvenile justice, criminal justice reforms, or not reforms, but issues, I should say. The way our law works right now, and it changed somewhat recently, but the way our law works right now, this deals with how old juveniles can need to be tried as an adult. So you think an adult's tried as an adult and a juvenile is tried as a juvenile, but it's not quite that simple. The way our law works now is that if you are 17 years old or older, even though 17, most people would consider that a juvenile, a 17-year-old can be tried in Louisiana for certain types of crimes that are really pretty serious ones. And but if you're younger than that, you would have to go through the juvenile system. So if you're 17 years old or older, you can be tried, and you actually are going to be tried as an adult for a felony case. So if you're 17, commit a felony, you're going to be tried as an adult, which means you can go, through the adult system, not have some of the protections of the juvenile system, ultimately end up in the adult, correction system, all of those types of things. But if you're 16 or less, you're supposed to be able to go, or you do go through the juvenile system, except there's some exceptions for really serious crimes. So the ones you would think of: murder, attempted murder, armed robbery, attempted robbery, rape, all of those types of things that are, mostly in the area of violent crime. We have a provision that says, even if you're 16 or 15 or even 14, in these certain circumstances, it could be possible for you to be tried as an adult, but only in these ones that are outlined in the Constitution. Only for the crimes that, and there are 15 of them that the Constitution says, only for these 15 crimes can somebody 16 or 15 or 14 be tried as an adult. So what this amendment would do is say, it would basically take those things out of the Constitution and say the legislature will decide with a 2/3 vote what crime a 16-year-old can be tried as an adult for. So what that means in practical terms is all those 15 things that a juvenile can be tried for now as an adult are not going to change because they're already in the law as well as in the Constitution. They're in the law, they'll stay. But the legislature with a 2/3 vote could in the future decide to say, we're going to add more crimes to that list. We're going to say for this crime or that crime, now a 16 or 15-year-old can be tried as an adult. So that is a big change to our criminal justice system as it, pertains to juveniles.
So this amendment would not be adding anything quite yet. It would just be allowing for that possibility.
Correct.
Okay.
The legislature first would have to happen. This amendment would have to pass. And then after that, the legislature would have to come through and pass legislation on its own to say, here are some other crimes that we were going to add. And, this is kind of a controversial issue because there's a big concern about, trying juveniles in the adult system because they lose some protections that they have. When you're a young age, brain formation is not what it is when you're 25 years old. You're still, dealing with kind of impulse behavior, not understanding consequences, all of these type things. And then there's also a better chance, for rehabilitation and all that. So there's a concern about doing something like that. On the other side, people, express concerns about younger and younger kids are committing more and more violent crimes than they used to. So, it's a lot to weigh there, but those are the kind of the issues that kind of came up in the discussion with the legislature.
So the legislature would both propose and create this list, basically?
Yes. So the existing list would stay. There's 15 on there, but they would be able to add to that list. And, it's funny. I mean, some of the things that have come up is like carjacking. Well, that one's not on the list, but, some people have talked about adding that. The question there is, well, certain kind of carjacking probably is on the list. If you use a weapon, well, then that would probably qualify, even though it's not carjacking on the list, it would qualify as like an armed robbery and an attempted robbery. Or if somebody was hurt or injured, that could be an aggravated assault or whatever thing. So that's one of the ones that's been used. Drive-by shootings is another one came up, but it's kind of the same thing there. If you're shooting at somebody, it'll be on that list. But those are the types of crimes that people have said should be added perhaps to that list.
So then what would be like a core word or phrase from this amendment to help voters remember what they're voting for when they see this on the ballot?
I think it would be, the question at the core of it is, should the legislature be able to decide what additional crimes a 16 or 15 or 14-year-old can be tried as an adult for, or should voters? The way it is right now, if we're going to add to that list, it would have to be approved by voters through a constitutional amendment. If we pass this amendment, then the voters would not weigh in on that. It would be the legislature instead. So it's kind of like, should the legislature be the ones to add to this list, or should voters by passing another constitutional amendment?
All right, thank you.
Yeah, and so we're just going to move on to the fourth and final amendment. So what is the significance of changing the elections in which voters can elect a judge like an Amendment 4? Because wouldn't more opportunities for public service to vote be a good thing?
This is one where it's actually more simple than all the ones I just described to you earlier. This one has to do with just kind of a weird change in the law. So what we have in our Constitution right now that says for judges, like these are state court judges, and we elect judges, that a vacancy has to be filled by election within 12 months, within a year. So if there's a vacancy occurs, they have 12 months to fill that vacancy through an election. I mean, through the elected process. So in the short term, in the interim, the Supreme Court can temporarily put somebody in to fill that position, but they can only fill that position, for less than a year. That's basically what the Constitution now says. And then you have to have the election. And mostly that works just fine the way it is. But this past year, we changed the way we elect some of our elected officials, including Supreme Court justices, which means that we've gone from what we have now is kind of an open primary that everybody probably is familiar with. You have a first primary, and if nobody gets 50%, then you go to the second one or the general election, and then that's the winner. Well, for some elections, like the governor and Bessie and actually the Supreme Court, we're going to another kind of system called party primary system. So that's based on party. So under this system, which granted most states have something like it. If you're a Republican or a Democrat, you run in a first primary. And if nobody gets 50%, you run in a second primary. And that makes you the nominee of your party after that. And then you run against the people from the other parties in the general election. What that does is, instead of having two elections for a Supreme Court judgeship to be filled, you could potentially have three. And if you have three, the way our election cycle works, it can be impossible in some cases to get that done within 12 months, which the Constitution says you have to do it within 12 months. So what this says is it kind of takes the 12 months out of there and says you just have to elect judges, Supreme Court justices in this case, at the nearest election possible. So that means it could be more than 12 months. It could be 15 months, something like that. But it makes the election code, align with our Constitution in this kind of very narrow circumstance.
Okay. And then when we're looking at what this amendment means as a whole, do you think it'd be fair to say that it's more or less just about changing the length of time in which a vacancy can be filled?
Yes. And I think I would also say it's probably technical more than anything else. There's not a big problem with what we have, except in kind of rare circumstances, just because the way our election dates work and our election cycle works. But there is, a window, there's an opportunity in some circumstances for us to be out of sync with the Constitution if there's a vacancy at a certain time. And this would just make sure that we stay in sync with our Constitution.
Okay, so you kind of touched on this in the last discussion, but are any of these amendments similar to legislation that we've seen passed in other states?
Yes, in some ways. I would say in particular, for one thing, going back to the juvenile justice issue there, juvenile justice reform or lack of reform, kind of whichever direction you're looking at it, has been sort of a hot topic in legislatures across the country over several years. What happened, in Louisiana in 2016, 2017, we enacted a bunch of reforms in juvenile justice, or actually in the entire criminal justice system, to try and get away from some of the excessive penalties that we had. We had, Louisiana's got the highest incarceration rate in the country, which we've had mostly for some time. We put a lot of people in jail for very long periods of time for sometimes crimes that are not, that serious, but we've had that history of that. So we kind of did a rollback a few years ago, along with many other states, to try and kind of make the sentencing more in line with the crime, and also hopefully, to not have so many people in jail that probably did not need to be in jail, who could be better trained and be back out on the street and being productive. And we actually saw some good results from that. But then, we went through COVID and crime rates went up. And what we saw in Louisiana and other places, the legislature kind of going the other direction and going back to kind of a tough on crime state. And this one kind of gets into that tough on crime thing. It has to do with how old you think a child or juvenile should be to be eligible or able to be tried, as an adult and go through all that consequences of that situation. So that's the biggest one. The other one, the Article 7, the Amendment number 2, that deals with just a whole lot of things that not necessarily other states are doing, but I think what you could say is it's trying to align our Constitution and shorten it and streamline it in some ways to make it look kind of like more what you see in other states as well.
Okay, thank you for that. And so for any of our listeners out there, this election might seem small or unimportant to some. And so just in your own words, why is it important to vote in elections, even those in which a congressional seat or governor's position isn't up for grabs?
Well, what we're dealing with when we deal with these amendments are, one of our fundamental rights, and I would also say responsibilities as citizens, and that is, the Constitution is our foundational document in the state. It's our framework for our entire government. And, the framers of our Constitution and our legislators have decided over time to put certain things in there or to take certain things out, but to either create protections or say that, if it's in the Constitution, it's really important. Or maybe if it's in the Constitution, it's not as important as we thought it was, and maybe we should take it out of the Constitution. But anyway, it gives that right and responsibility to voters to do that. And look, it in most cases, constitutional amendments don't change the world for everybody. Sometimes they're just kind of more technical or things that need to get fixed. Sometimes you're, creating a protection that, maybe you think this ought to be protected, or maybe you're creating a tax exemption for a group of people that feel like they deserve, a tax break because of their circumstance or their situation. Those are all things that our Constitution says voters are supposed to decide, not the legislature, if it's in the Constitution. So I think that's why it's important. But the other thing is that rewrite of Article 7, dealing with all of our state, not all, but a lot of our state finances and local government finances too, is a really big deal. And, a lot of work went into it during the legislative session that we had in November, the special session to kind of create this. I would say from our perspective, it's not perfect. There's some things we probably would not have put in there, but we don't get to pick and choose on this one. It's either yes or no. But there's a lot of good stuff that this amendment does, to help streamline, our government, make it more efficient and, provide pay raises and do some other kind of, smart fiscal policies, things that are smart in terms of protecting our money, our taxpayer dollars. So people should take a look at that one in particular and pay really close attention to it. And I hope a lot of people will go out and vote, because it's kind of sad when, big decisions are made with only a relatively small number of people making that decision.
Yes, and you have given us lots of valuable information. But is there anything that we haven't touched on that you possibly want to elaborate on?
No, I think you've done a pretty good job. I would say for folks who want to find out more, our organization is called Leaders for a Better Louisiana. And you can go to our website at leaders@betterla.org. Our leaders, no, I got to go back. betterla.org. Sorry. New organization. I still can't even remember our new website right now. But it's betterla.org. betterla.org. And we will have some information just in the next few days out on that to try and help you kind of navigate that a little bit further. And certainly if people have questions, we get questions, people call, and they're welcome to give us a call, and we're happy to, try and send you some more information.
Well, thank you so much, Mr. Erwin, and thank you all, our wonderful listeners. Once again, I'm Kierra Evans.
I'm Kathryn Slaton.
And I'm Makala Borland.
And special thanks to our producer, Mr. Noah Saucier. Thank you so much for watching. You guys have a wonderful day.